Our task tonight is to try to persuade you that hate speech on campus is not protected as free speech. That is, we would like you to convince you to vote no in response to tonight's proposition. My argument is rather simple. 1, campus speech is not protected free speech. 2, instead, principles of academic freedom govern campus speech. 3, because First Amendment speech principles do not apply, at least not fully so, to campus speech, hate speech on university campuses as a form of campus speech is not protected free speech. 4, moreover, under these principles, hate speech has no academic value and thus no place on campus. Let me explain and defend this rather simple logic after I introduce our esteemed colleagues arguing on the other side. It's an honor and pleasure to share the opportunity to debate with my 3 outstanding friends, and I want to offer my gratitude to them for joining us tonight and to acknowledge in particular Professor Robinson's gracious and gamely willingness to step into this debate a mere few hours ago. Eric Robinson is Associate Professor in the School of Journalism and Mass Communication, who also teaches media law here at the law school. He has practiced media law for more than 25 years and serves as of counsel to Finno Law in Charleston, South Carolina. He has previously taught at the Louisiana State University and City University of New York Graduate School of Journalism, among other institutions. He has published widely, including his 2021 co-authored book, Cyber Law and Ethics, Regulation of the Connected World. He graduated from Vassar College, completed his law degree from Syracuse, and earned his Ph.D. in mass communications from Louisiana State University. Meredith McPhail is attorney for the Civil Liberties Union here in South Carolina. She has also worked as a criminal defense lawyer in Charleston in both trial and appellate roles. Prior to her work in criminal defense, Ms. McPhail clerked on the Ninth Circuit Court of Appeals in California for Judge William A. Fletcher, who was himself a law professor at Berkeley before being nominated to the Ninth Circuit. She's a graduate of the University of Southern Mississippi and majored in English and Spanish, and subsequently graduated magna cum laude and 4th in her class from the University of Michigan Law School. And as most of you already know, or at least the law students here, Samuel Boyd is a second-year law student here at our own Joseph F. Rice School of Law. He is the president of the Technology and Law Student Association, an editor for the South Carolina Law Review, and a legal writing tutor, among other activities. He graduated summa cum laude from the University of South Carolina, Aiken, with degrees in applied computer science as well as political science. This summer, he will intern at the Nelson Mullins law firm here in Columbia. Now let me return, and please welcome. Let me return to my argument and my first proposition. Remember, it is that university campus speech is not free speech. Universities are not open public fora. Free speech principles do not apply in full to campus speech. To the extent that free speech principles apply to a public university campus, they do so in a way that is subordinate to the institutional goals of universities. 3 facts about university life illustrate the proposition that campus speech cannot and should not be viewed as examples of free speech. And that hate speech cannot and should not be viewed as well as examples of free speech. First, a bedrock principle of First Amendment protection for free speech is that government may not compel speech. Government can't make us speak, can't demand what is orthodox, and can't tell us what to say. But on university campuses, speech is compelled all the time. Students can be compelled to participate in class, and experienced law students on cold call know all too well. Students can be compelled to produce written work on assigned topics, and within those assignments to explore particular viewpoints. For us faculty, we are compelled to give lectures and lead discussions in our classes. What is more, in the process of promotion and tenure to becoming full professors, faculty must profess new ideas. They must, as the saying goes, publish or perish. 2, under the First Amendment, content regulation is strictly scrutinized, meaning that it is permissible to regulate the content of speech only under the most exacting and demanding set of justifications. Government can't prescribe what shall be orthodox or regulate speech because it disfavors its content. But within universities, content regulation occurs all the time. For faculty, norms of their respective and academic disciplines apply. And by disciplines, I mean law, philosophy, chemistry, physics. Both students and faculty are evaluated for the content and quality of their speech. For example, academic peer review constrains and guides what counts as acceptable ideas and arguments that merit publication. The subject matter of a professor's writing is evaluated under standards of their academic disciplines, constraining the nature and content of faculty writing. Blog posts on whatever happens to be on a professor's mind may be protected by free speech, but they ordinarily don't count towards satisfying publication requirements or the production of knowledge. This means that judgments about good or bad ideas regulate the content of campus speech, the generation and dissemination of ideas. And for students, you know all too well that content regulation in the form of assignments and grading is really familiar. Moreover, for both faculty and students, subject matter relevance is a constant constraint on content within classes and courses. A class in constitutional law should not spend appreciable time discussing French symbolist poetry, as tempting as that might be. 3, under First Amendment free speech principles, public discourse should be uninhibited, robust, wide open, as the Supreme Court admonished in the foundational case, New York Times v. Sullivan. The court has explained that under the First Amendment, no one has the power to close off debate or to say what shall be orthodox. There are no false ideas under the First Amendment. Instead, there is a marketplace of ideas in which debate is always open and reasons don't have to be given. Free speech expression can be arbitrary, opinionated, unreasonable, and it is still protected. But within universities and on campus, inquiry is not always open. The university is not a public forum. We close off debate all the time. The university curates, through academic disciplines or through interdisciplinary interaction, intellectual inquiry. It is not a public free-for-all. We develop normal scientific consensus and establish agreement in normative practices. For example, we live within a paradigm of quantum uncertainty, not Newtonian physics. And likewise, we live under the ideal of racial equality and are thus not open to debate about the merits of returning to Jim Crow segregation. We demand reason and reasonable inquiry subject to reasoned evaluation. There are false ideas, wrong answers. We do not debate Holocaust deniers. We do not need to reconsider whether it might yet turn out to be true that the earth is in fact the center of the universe. Universities are not open public forums. Academic disciplines organize inquiry, produce knowledge, and establish their own orthodoxies. This is not to say that they are completely closed and fixed. If you've encountered Thomas Kuhn's famous explanation of the structure of scientific revolutions, you are aware that today's knowledge is subject to future revision, perhaps revolutionary revision. But until and unless that happens, an academic discipline is entitled to its truth and will organize and limit the range of intellectual debate accordingly. So, to my second proposition, you may now be asking at this point something like the following. But I thought universities were supposed to be places of open inquiry and debate. If free speech principles do not fully apply, then doesn't that undermine a university's important educational mission? To educate students and encourage critical thinking. The answer is the second claim in my argument, that principles of academic freedom apply instead. Academic freedom protects free and open intellectual academic inquiry. To the casual observer, academic freedom looks a lot like free speech, and indeed there is a lot of overlap. Picture a Venn diagram of two overlapping circles that almost completely coincide, but they don't. They don't fully coincide. They are not the same. Academic freedom supports free and open intellectual, literary, and artistic inquiry. This is very broadly interpreted and implied, but it is still more bounded than free speech in the public sphere. As we have seen, academic freedom is subject to norms of academic disciplines that have their own evaluative criteria based in knowledge, reason, intelligence, and evidence, norms and virtues that need not apply in the public sphere's free speech zone. Within universities, we are encouraged to seek new ideas, make new breakthroughs, gain valuable new insights. We welcome debate and disagreement. Initial skepticism is an academic virtue. Demands for evidence and more inquiry are the norm. But there are limits defined by general norms of academic exchange and the specific norms applicable within academic disciplines. Academics demand evidence, reason, and logic and do not accept their opposites. But in the public sphere and under principles of free speech, by contrast, evidence-free, irrational, and illogical expression is said to be just as valuable as their opposites. Remember, for free speech, there are no false ideas. But the university is a place of academic freedom, not freedom of any and all speech. Universities seek after light and truth, as one university motto announces, or they recognize that learning humanizes character and does not permit it to be cruel, as the South Carolina motto extols. Universities seek truth and wisdom while producing knowledge. They do this by creating a community of scholars and students who share in a common academic endeavor. And within this academic community, universities maintain standards of equal respect for its members in order to better foster its focus on academic inquiry for all. In this context, hate speech regulation is normal and desirable. Hate speech is of a kind not directed towards ideas, but towards individuals and groups in ways that commit ad hominem fallacies and thereby violate norms of rational discourse. 3, so the third claim in my argument, hate speech as an incident of campus speech is therefore not protected on campus as free speech. Hate speech, if it is to be protected, must find its protection within principles of academic freedom or in relation to a university's mission. If a type of speech, such as hate speech, is inconsistent with the educational and research mission of the university, then it can and should be regulated. My colleagues will say more, but hate speech produces harms inconsistent with the university's mission. It undermines the equal dignity of everyone in the community. It undermines open participation. Hate speech signals that some voices don't matter or are deemed by some to be lesser based on criteria that are irrelevant to academic questions. There is no free speech right to turn educational and research institutions into Speaker's Corner at Hyde Park in London or any other version of an open public forum. This does not mean that universities never err or cannot overregulate, but when they do so, they do not violate the First Amendment. Rather, we evaluate them for how well they live up to their own academic freedom commitments. But we have to decide in framing campus speech. Are we a university in which reasoned and reasonable debate and classroom instruction are the model for what we do? I say yes. Or are we the public sphere where cacophony can be celebrated and arbitrary, unreasonable opinions can frequently be heard? I hope you agree, no. Let me make one final and additional argument. Free speech is not under fire. We were going to have a colleague from fire, and that was a pun. But, it still works. Confusing free speech with academic freedom and their interplay causes confusion in the public and makes it appear that free speech is threatened by campus speech regulations, including hate speech regulation. I have two arguments in response to this worry that there's a crisis of free speech on campus. First, the bootstrapping argument. Outside groups often provide funding and enticement to local student groups that are national affiliates to issue invitations to speakers. They sometimes propose and agree to fund provocateurs, mostly within what we might generously term public policy debates. And these provocateurs will say things that are controversial and some will find offensive. So first, there is a degree of a lack of authenticity in the generation of these controversies that are not organically or locally derived. They are ginned up by outsiders to the university using university organizations to accomplish their own ends. These are almost never the products of sincere academically sponsored debates or events, the impetus for which begins within a local university's desire to hear a speaker. No academic discipline has anything to learn from the white supremacist views of a person like Richard Spencer, for example. Second, note that those who seek to produce controversy use the university as the platform in order to produce their own deplatforming. They could rent a local lecture hall or a theater, but nobody would come or care. But if they can get some students riled up and administrators worried, well, that's the whole point. so that when outsiders or insiders engage in forms of hate speech on campus, broadly conceived, they no longer speak within academic disciplines and therefore cannot demand a campus platform. The white supremacists of the world are free to speak in the public sphere, but do not engage in the kind of reasoned and reason-responsive debate recognizable within any academic discipline. Second problem with "there is a crisis of free speech" argument, the both sidesism problem. Open academic inquiry, as I have suggested, does not have to privilege or accept all sides of a debate. Free speech does. Flat earthers are unwelcome in our geography department. Has anyone heard of phlogiston? No need. Phlogiston theorists from the 19th century are not part of modern chemistry departments. We do not need to debate the fact that the earth is not the center of the universe, or whether the atrocities such as the Holocaust ever occurred. Similarly, there's no requirement to allow hate speakers to speak or to listen to them. Academic disciplines and institutional prerogatives decide what counts and whom should be heard. Between facilitating external bootstrapping and a false call for both sidesism, FIRE, organizations like FIRE, and others make it sound like there's a free speech crisis on campus, and that this crisis requires us to accept hate speech as the cost of having free speech on campus. But there is no such crisis, and hate speech never needs to be protected as free speech on university campus for us to have open, wide open, robust debates. If hate speech is to gain any footing, it must justify itself according to principles of academic freedom instead. So, to summarize my argument, 1, free speech principles do not govern the exchange of ideas on campus because A, our speech is and can be compelled. B, content is and can be regulated. And C, debate is and can be cut off when consensus is reached or knowledge is produced. 2, instead of free speech, principles of academic freedom apply, under which the academic exchange of ideas is protected. But a public sphere free-for-all need not be tolerated. 3, hate speech on campus as a form of campus speech is therefore not protected by free speech principles. Instead, hate speech on campus is and should be regulated by principles of academic freedom. Therefore, I urge you to vote no in response to the proposition that hate speech should be protected as free speech on college campuses. Thank you.